Technical this one. Mr. Richards, I gather you're a good deacon. You'll lead us in a word of prayer. Start the meeting.
Let's bow our heads. Heavenly Father, we thank you for waking us up once again this morning and for bringing us here to discuss the nation's business. Give us clarity of thought, Lord, as we go through a very important piece of legislation. In Jesus' name, amen.
Thank you. Any apologies for absence? No? All right, then welcome one again this morning. I was reminded this morning that in the resolution to Parliament, we did and we do intend to do hybrid meetings from time to time. But given the potential controversy in the beginning of the legislation, we thought it would be good to do face-to-face. Of course, that has gone pretty well. And it looked like the second phase, which we didn't think would be any controversy, is where we're having discussions. However, I intend to, again, I made a comment last week, but I want to read for clarity because it emerged that from a couple of comments I made. Well, a part of a comment I made went viral in the media, and we're getting a ton load of letters which may almost overwhelm the parliamentary clerk. Also, with the recent events in the FLA, other comments are coming in. And I think it would be appropriate before I start this meeting this morning to read for publication, put into minutes, two short statements. First one, let me begin. A comment was extracted from my discourse in Parliament on Thursday, March 10, 2022, that went into circulation and have generated more discussion. Many did not hear or note the entire discourse. I'll therefore lay out the facts as they are. First, the draft legislation proposed that the grant of firearms users permit to juniors should not be awarded to anyone younger than age 16. No age of 18 was mentioned. Age 16. The Jamaica Rifle Association, in its response, suggested that the policy should allow for the following 5 items: air guns age 12, shotguns 20 gauge age 12, shotguns 12 gauge age 14, 22 LR rifles age 14, pistol and rifles age 14. I indicated without any ambiguity that I had concern about D&E, that is pistols and rifles. I'd further say that should there be a reintroduction, and to be a reintroduction, it no longer exists, then it should be done through the Jamaica Combined Cadet Corps. At no time did I suggest any objection to air guns, shotguns, 12 gauge or 20 gauge bore. That is A, B, and C. The country should be reminded that rifle clubs were part of many schools up to the mid-70s. However, they were all closed due to risk assessment carried out at the time as gun violence had exploded in the country. There are no pistols and rifle clubs for juniors at this time, and no access by juniors access. This is a new proposal, and reintroduction must be carefully considered. In fact, the mistake I made was I've said it should be done. It is what is being done now. Juniors don't have access to pistols and rifles. Shotguns in Jamaica are really used as weapons to commit crime and are more used as sporting equipment. That's the fact of life. In fact, shotguns are essentially sporting equipment in Jamaica today rather than a weapon. Even those who have shotguns use their sidearms as for protection. The jury will be called before the Joint Select Committee currently reviewing the draft bill for a fulsome and informed discussion, and the matter reviewed appropriately. This I want to read and have it published so that there is no dispute or any controversy surrounding air guns and shotguns at this point in time. And I think there might be about 100 letters a day on that issue.
So, Mr. Chairman, you're just making a point that this matter is for future consideration in sittings of the committee, and that you have not closed the door on.
No, in fact, I'm saying I have no objection to air guns and shotguns, and therefore it could be included because they can go as low as age 12. I think the law doesn't allow certain liability below age 12, and therefore I have no problem, but would allow the GRA to come and make the statement.
To come and make that, and then we will further discuss it at that time. Okay.
The pistols and rifles, I said, is a different issue. Do you want to introduce it at this stage when it was taken out at a certain stage when it was even less of a risk at the time?
But I just think
I'm willing to discuss it.
Yeah, because the GRA made a case for sport shooting, pistol sport shooting, that if we want to compete internationally, we have to start them younger than 16.
But I said, remember, it was a popular sport at one point and was stopped by the own risk assessment. So whatever reintroduction have to be given a stronger review than shotguns, which are active now and well used by everybody.
In anticipation of that presentation, Mr. Chairman, could we ask the GSF if they have can provide any information on sport shooters or licensed firearm holders generally committing firearm offenses? I'm not talking their license expiring and they're not renewing it on time. I'm talking, shooting, etc., otherwise than in lawful circumstances.
I don't envisage any long debate on the air guns and shotguns, to be quite frank with you. I think it was just a procedural issue where it was not really in there early. Because I said, shotguns are essentially sporting equipment in Jamaica today. And it didn't cross my mind when I was talking about the other thing. It wasn't part of my thought process, to be quite frank with you, which is why the number of petitions, it wasn't in my mind at all. Right? The pistols is of concern because in addition to any local issues, I said it was removed because of and rifles for the then risk assessment. And while we don't have much data on accident by children, there are two things to bear in mind. The incident of children shooting each other in a country where it is easily available is quite high with our neighbor. There are figures on those. In addition to that, we currently don't allow toy guns into the country.
Which is perhaps an overreaction as well. But, Minister, all I would say is that, remember, these sport purpose licenses can be restricted to the ranges. In other words,
we are with you.
The junior can't remove.
As I said, my first level was Cadet Corps, because Cadet Corps is assault. The rifles are usually stored at a camp for the JDF, and then they go to the range when required. So there are discussions can be held around it. Wasn't right, but I couldn't allow for a free-for-all where any parent can give their child permission to use a firearm at home. That would be absolute, out of the question completely. Second one is more clarification because, again, both have said doing it here and they're allowed to go to the press. Because of the report that came out recently, and I know that a lot of policy shifts already and things done to correct some of the measures, I thought it would be appropriate to read it here as well. The recent Integrity Commission special report on the Firearm Licensing Authority has resulted in a series of comments and suggestions that require a response from the Ministry of National Security. First, let me note the report covers the period 2012 to 2018. Since 2017, there have been significant policy changes aimed at correcting the irregularities and deficiencies highlighted in the report. I've noticed that many of these corrective measures will be codified in the new Firearms Prohibition, Restriction and Regulation Act 2022. So I urge that those who are wishing to comment, read the act and then give us some comments that we can relate to and discuss objectively. Following the change of the board of the FLA in 2017, a number of policy changes have been implemented. There have also been significant ministerial shifts in that the Minister of National Security no longer reviews the recommendation of the review board. This Minister of National Security no longer reviews. Do not review. That's something that started last week. I've never done it, which is 4 years. We found it inappropriate that a policy unit within the ministry should be asked to review the work of a panel headed by no less a person than a former president of the Court of Appeal, supported by a former senior deputy director of prosecution and a retired senior police officer. In fact, we find the character of the chairman of this panel to be unimpeachable and beyond reproach. As a result, the findings and recommendations of the board are accepted as recommended. In addition to that, where the 90-day period for the review board to consider an application has passed, I do not intervene, but may ask to recommend where there is a genuine case through the Chief Executive Officer of the authority for the review board to take an early look at such an appeal. I do not exercise any discretion to examine appeals delayed beyond 90 days. Additionally, administrative processes have been put in at the FLA to prevent the kind of errors and deficiencies outlined in the Integrity Commission's report. Some of these are In 2017, Major General Anthony Anderson, former chairman of the board of the FLA, introduced a system where only board members who attend the meetings are allowed to sign off on applications, and reports should be signed by all board members attending. Greater relationship with the National Intelligence Bureau and other intelligence agencies established as the FLA moved towards a more system check for the security clearance of applicants. The board no longer reverses its own decisions or that of a previous board. The board no longer considers applications unless all security clearances are attached to the files. The Morph Wrap ID machine is installed, which provides electronic reports on the criminal background of any of all holders or applicants within seconds. Discontinuation of the practice where staff members of the FLA or the third parties sign for or collect packages on behalf of applicants or holders. Critical part of what is done because that allowed people who are not even in Jamaica to license the firearm somewhere in jail. Third-party renewals have been discontinued totally. Third-party renewals. In other words, somebody come with an application, where your ministry, where they go in, apply, and nobody knows where the gentleman is. There has to be a physical presence. This is essentially designed to prevent reports of people who are incarcerated getting a firearm license. Right? And it is not a matter that a minister will necessarily be aware of. Right? It is a board matter, that issue. Online tracking system for application has been established, which is fairly new. The authority's website has been renovated, and there has been upward of 70% turnover of staff with the authorities in 2017. All staff members that are brought in are fully vetted and undergo integrity testing. All board members must pass the fit and proper criteria, and so the deficiencies have been corrected and all the processes and appointments still kept under review for necessary improvements by either suggestion or review from process. Much of what is referred to above will be codified in the present Firearms Prohibition, Restriction, and Regulation Act.
Thank you for that statement, Minister. Will we get a hard copy of it? And let me just add that with respect to ministers operating on a recommendation of the Firearm Review Board, I endorse that 100%, and it is consistent with how I behaved, particularly in the two cases raised in the Integrity Commission's report. And it is curious that they made no reference to the report or recommendations of the Firearm Review Board in those cases.
No, thank you, Senator. And also add that it was a little bit, there's something wrong about reviewing a review board panel by the staff. The staff did it, but it just didn't look appropriate that a former director, I think at one said, is the president of the Court of Appeal now, former president of the Court of Appeal. The last said was the former director of the prosecutions. And then we end up with the policy officer reviewing it to say to the minister, accept or not. It just didn't make sense. And part of the problem with that is that we end up with a huge backlog. And that is, I didn't put in this, but we are clearing it up. We have made arrangements with the FLA to take steps to clear out the backlog. We have had several steps, in fact. Back in 2020, I think it was, the director is maybe, I requested my ministry, I don't know if it was carried out, that they should send back all the files older than 2 years old, and asked the members to reapply, because it was pointless keeping them. In any case, they can reapply after 2 years. The others are going to review, and we have made one attempt at doing it. We got to a fair number, but we are doing a second round, which I expect will to have all backlogs cleared by the time this bill is ready, by the process that we have adopted now. So that at that point, the review panel is in a position to operate on a current basis. Let me thank you. Our bill, I'll ask.
Chairman? Yes.
Is a presentation. You want to take it before, or should we just start and take a break?
Let's take the presentation.
Huh?
We concluded last meeting at clause 26, which was the end of part 3, to commence part 4 today. But since the FLA presentation or the Forensic Institute, we could take that.
Yeah. Let's take the Institute of Forensic Science and Legal Medicine presentation. They have an excellent record in their refurbished facility. Go ahead. Good morning. Good to see you.
Good morning, Minister. Good morning, everyone.
You want to give me a name? I know it's superintendent, but can you give your name for the records?
Yes, sir. So my name is Miguel Bernard. I'm an Assistant Superintendent of Police, and I'm also the head of the Firearms and Toolmark Examination Department at the Institute of Forensic Science and Legal Medicine. The Firearms and Toolmark Examination Department is also commonly referred to as the Ballistics Department. Just for context, I have worked at the Forensic Institute for the last 14 years, and I'm a trained ballistics expert. The department treats with mainly examining firearm-related components and firearms, components such as bullets, cartridge cases, and ammunition, other ammunition-like components. The department is also tasked with doing examinations to assist with identifying linkages between crime scenes using the integrated ballistics identification system. Now, the first thing I would like to speak to in this presentation is for us to look at this image here. And while I won't solicit any answers, as it says, what is this called? The common response, it is called a bullet. Now, this is not a bullet. This is a cartridge. So what is a cartridge? A cartridge is a single unit of ammunition consisting of a cartridge case, primer, propellant, and one or more projectiles. And I stress the word projectiles, and I'll speak to that further. So a single unit of ammunition, it essentially has 4 main components. So here are the components. You have the projectile. So on the left, that illustration is a cutaway of a 9mm or 9mm Luger cartridge. The projectile in this cartridge is a bullet. You have the case, which is the container for all the other components. You have the propellant, which is what is used to generate the expanding gases that propels the bullet through the bore. And we also have the primer. So these 4 main components are what typically makes up a single unit of ammunition, and to be specific, firearm ammunition. Just to be clear as well, the primer is what the firing pin makes contact with in the firearm, which ignites the propellant. The propellant generates expanding gases, which pushes the bullet through the bore or the barrel of the firearm. We also have another type of cartridge that I want to illustrate here, which is a shot shell. A shot shell is used in the shotguns. And this shot shell has multiple pellets or shots. So this is where the term comes from. Shot is actually these small pellets. And that is the reason why we like to, as firearm examiners, we prefer to use the term projectile, because it's not only a bullet that in many instances is expended from the firearm. You have pellets, you have shots, You also have situations where they are modified. Some persons you will find shot shells that have nails in them and different type of projectiles. So bullets are projectiles, and you have several other types of projectiles. This shot shell also has some other things that you did not see in the previous image, like the wad which separates the projectiles from the propellant, etc. But the four main components are still there: the case, the primer, the projectile, and the propellant. So the technical definition that we use is that ammunition is one or more loaded cartridges consisting of a prime cartridge case, propellant, with or without one or more projectiles. And the definition that I see here in the proposed definition in the draft is any article consisting of a complete cartridge or round or any component or cartridge or round, and includes the four components: cartridge case, primer, propellant, bullet, or projectile. As I indicated, bullet would capture both projectile and any other type of projectile that is expended from the firearm. I also want to
a round and a cartridge are the same thing?
They are the same thing. We typically, as firearm examiners, don't use the word round, but it's really a military term. I don't know what happened. Oh, I personally don't have an issue with it, but in the strictest of sense, we use the term cartridge. I'd like to also highlight another term, missile. A missile, I have two definitions here. It is generally accepted as an object that can be thrown or projected to strike at a distance. However, we typically don't like the term missile in speaking to firearm projectiles, because in military terminology, it is a guided weapon capable of being self-propelled and is designed to deliver an explosive warhead. So, for example, what is taking place in Ukraine now, they are using many missiles there. So the projectile that is discharged from a firearm is typically, in the military sense, not a missile. And if I may, while I was on my way here today, a situation came to mind in 2013, and I found the article, or one article that spoke to it. And this one was from the Los Angeles Times, where it says 3,300 warheads. That's another term that we don't use, or we don't like that term. But we see it a lot of times when bullets and bullet fragments are submitted to the lab. On the submission form, it is stated as a warhead recovered from the body. The article is titled 3,300 warheads, missiles, machinery found at Jamaican port. And if I may just quote two sentences, the Jamaican authorities have seized 3,300 warheads and a missile-making machine at the port of Kingston and sought help from international police in tracking the shipper, etc. And from my recollection, that caused quite a stir in the law enforcement community by that statement there. And it also says, the second sentence, it was unclear from any of the reports of the seized ordnance how large the warheads were, what type of launch device they were intended to arm, or whether the shipment and destination was Jamaica or another country. The reason is, as I explained, the concept of a warhead is something that is on a missile that is designed to explode upon impact, and the concept of missile is often interpreted in military terms. So we prefer the term projectile, which, as it says here, is an object propelled by external force and continuing in motion by its own inertia. So it is not self-propelled, it is from the expanding gases that place the projectile in motion, and it continues in motion from its own inertia. And if I may say one final thing on that particular incident, that is one of the reasons why we have suggested, and I have personally, it's my personal opinion as well, that component parts of ammunition should be considered based on the fact that in that particular instance, for example, from the best of my memory, the person who was behind that shipment was eventually only able to be charged for uncustomed goods, because in the strictest of sense, the legislation didn't make any accommodation for component parts of ammunition. So here it was, the person had thousands of bullets, there were thousands of cartridge cases, thousands of propellants, thousands or hundreds maybe, propellant and primers. Along with that were also machines to assemble these parts together. So they have all of the components, they had the machines, they even had lead bars and the smelter to melt it down and make bullets. But we were only able to charge a person for component parts, for uncustomed goods. So it is my firm opinion, personal opinion, that component parts must be considered, and based on my perusal of the proposed act, it is mentioned that component parts are also considered ammunition.
If I could just get a clarification. So what you're saying then is that if shots were fired in a community and shell casings were scattered around on the ground and someone picked up the shell casing, then they would be at risk of being charged for illegal possession of component parts of ammunition?
Yes, sir. I appreciate that question. And I was, before the beginning of my presentation, I was saying to Mr. Bailey, to my left, that in a scenario like the one I outlined, if it is that based on the context that those component parts were found, say, for example, we are looking at a similar situation with the Dangerous Drugs Act, where based on how the components were found, it is clear the intention is to manufacture this ammunition. I very much appreciate and understand the question, and I believe that it would have to be in a particular context that we are looking at component parts of ammunition being considered as ammunition. Not necessarily in an instance where an expended cartridge case is picked up from from a crime scene for argument's sake, but in the context where we have all of these components, then certainly it is my opinion that someone shouldn't be able to just be charged for nothing or for uncustomed goods.
Where someone, any used component can be reused?
So certainly the propellant couldn't be reused because it would already be burnt. The primer could not be reused. However, the cartridge cases, and I've seen several of those cases where we are getting reloaded ammunition. So the container for the ammunition, technically the bullets could be reused as well. The cartridge case could be reused, but the primer, once it is expended, it cannot be used. But what you will find is that if, for example, you have a batch of primers, then I can take a used or expended cartridge case, remove the primer, and put a new one in it from the batch of primers that I have. So some cannot be reused, but once you have the components, there are certainly parts that you can interchange and create a new unit of ammunition.
Okay.
So the next thing I'll speak to is for just for clarity for everyone, the general firearm types that are there. The very first type, which most of us should be aware of, is the pistol. And the defining characteristic of a pistol is that it has the chamber as part of its barrel and is designed to be held with one hand. So in a nutshell, it is a handgun which has the chamber as part of the barrel. So just a quick cutaway so you can see that here are the components. We have the slide at the top, an essential part. We have the barrel that the bullet passes through. It has the chamber that the cartridge is seated in as part of the barrel. So the chamber and the barrel, they are together. We have also, just speaking to the main parts, we have the receiver, and it is called a receiver because it receives all the main components. And I will also just mention the magazine. And I put the magazine there for a specific reason, but you will see as I go along. So those are the main components of a pistol. We also have the revolver. Yes, sorry about that. We also have the revolver. So the revolver, it has a rotating cylinder with multiple chambers. It is also a handgun. So again, the main parts, we have an external hammer. There you have the cylinder which rotates and it has multiple chambers. We also have the barrel and the frame. We typically use the term frame and receiver interchangeable. For the most part, we tend to use the word frame when referring to revolvers and receiver when referring to pistols, but they are essentially interchangeable. We also have submachine gun. Now, the submachine gun, the main distinction is that it chambers pistol ammunition. So, your 45 auto, 9mm Luger, 380 auto, those are pistol examples of pistol ammunition. So it chambers pistol cartridges and it is capable of firing on fully automatic action. So this illustration with this photograph with this firearm, which is a H&K MP5, it has a selector switch that allows the firearm to be changed from semi-automatic to fully automatic mode. And it is normally compact and designed for use in close combat. I will say this, that over the last few decades, there's becoming some blurring of the lines with some of these types of firearms, where, for example, a 5.56 millimeter or your M16 type cartridge, which would normally be seen in a rifle, you see now shorter guns, albeit not efficient, albeit not effective, chambering these type of ammunition. So there's some blurring of the lines, but it typically holds nevertheless. So this is a submachine gun. Now, I like to ask, based on, just to illustrate a point, if we look at these two images, what type of guns are these? Both of them look essentially identical. This is a submachine gun. This is a pistol. And the main difference that separates these, for example, the one on the left is a Uzi submachine gun, and the one on the right is a Mach 11 pistol. The one on the right can only fire on semi-automatic mode. So essentially, it's just a big pistol. It looks cool. These criminals, they might prefer it because it just looks cool, but it really adds no added value other than the fact that it has a larger magazine capacity. So these are the reasons why.
Aren't the gunsmiths able to modify the pistols to make them fire on automatic mode?
Yes, sir. They are able to modify them, and that is why an essential part of our duty or role that we perform at the lab is when these firearms are submitted, we are the ones who have the task to classify these weapons as submachine gun, machine pistols, etc., based on how they function and modifications.
So if that pistol on the right was modified to fire automatically, you would then define it as a machine pistol?
It would be a machine pistol, which essentially is a submachine gun.
Thank you.
Yes, sir. The next firearm we have there is a rifle. This is your AR-15 type rifle. And the rifle is typically defined as a firearm with a rifled bore.
Just to get a little perspective from you, the Rifle Association in its commentary asked for a revision of the definition of modification of a firearm. It says that they said that the manufacturers of firearms create a set of activities that are to be executed by firearm users that were intended to modify the function and performance of firearm. Example, changing the choke on a shotgun, stretching magazine springs, changing seals, changing grips, changing recoil spring, dependent on the ammunition being used, making adjustments to adjustable components of the firearm to suit the user. And they're saying that they were recommending that modification be defined as an alteration and effecting repairs that affect the ballistic signature, barrel length, identification marks, or diminish the sound caused by firing a firearm. What's your take on that?
So I agree with that suggestion for the most part. Where, for example, and forgive me if it was said, I don't remember if that definition that they put forward, if it covers, for example, the question that was just posed, modifying the weapon.
So there is a restriction on modification, and modification can only be done by the licensed gunsmith at the location that they're licensed to carry out the modification work.
Okay. Yeah, so I understand where, for example, one example that was used, modification of the choke of the firearm. That would definitely not be something I would recommend if, based on the definition that is coined, if that is captured in it, then that would be inefficient. It wouldn't make sense. Because, for example, doing target shooting or bird hunting, etc., the modification of the choke essentially just controls the rate of dispersion of the pellets from the barrel. So when the pellets exit the barrel, they disperse in a conical manner, and by modifying the choke, it will cause the pellets to remain compact for a longer distance, or they start to disperse immediately after exiting the barrel.
So the current definition in the bill is that modification in relation to firearms or ammunition, A, means any act that results in a difference in the function or performance of the firearm or ammunition, and B, includes alteration and effecting repairs. And they're saying it should be modified instead of so broadly, is if the repairs, effecting repairs that would affect the ballistic signature, barrel length, identification mark, or diminish the sound caused by firing a firearm.
What I suggest is maybe we would need to look more at defining specific points. So, for example, the example with the choke, I totally understand that wouldn't be efficient. It wouldn't make sense to have a definition that captures any modification to the choke. However, for example, modifying the trigger.
Well, that's an example. I don't know that it would specify. The point is that the manufacturers permit a range of things to be done that would result in a modification that would impact performance depending on the skill of the user. So for the purposes of the law, they were saying, instead of casting it widely, to speak to modification that is permissible, that they prohibit modification that would alter you, the expert, being able to identify the firearm in the first instance, the firearm that was licensed,
the ballistics
authorized for use.
signature, essentially. So, for example, if persons modify the trigger to allow the firearm to have a lighter trigger pull, then that wouldn't be something that would affect the ballistic signature. It would not. But that would be something that I personally would believe that persons shouldn't be able, without being authorized, to be able to do that sort of modification of firearm. I would also look at...
Remember now, under the law, the proposed law, only someone who is authorized as a gunsmith would be permitted to make modifications and repairs to the firearm.
Understood.
So it's not something that is going to be done at large. If so done, it would be an offense. So the recommendation in respect of those who are licensed to repair and modify, that the definition of what amounts to modification should not be cast so widely, since you may not be able to answer fully, no, since you're midstream the presentation, but we'd certainly ask your perspective on some of these, given the role that
I certainly understand the point. And I would want to ask a question if, based on what is being suggested, if, for example, changing the color of my firearm from regular blue steel to pink, if that would be something that would be allowed based on the current proposal.
Modification is proposed to mean any act that results in a difference in the function or performance of the firearm or ammunition, and includes alteration and effecting repairs.
So that wouldn't be considered a modification, because changing the color wouldn't affect the performance of the firearm. The reason why I asked the question is just drawing from a lot of my experience in terms of courtroom testimony, and to see whether or not there is any possible thing that needs to be considered as it relates to that. I know of many instances where, based on the witness testimony, a lot of times the witness would say, "I see the man with a shine gun," where they're talking about like a chrome pistol. I'm just wondering if persons are able to just modify the color, if that could affect those instances.
Impact the description that is seen for the purpose, so it may create a discrepancy if the firearm that was seen turns out to be of a different color than the firearm that was recovered when the investigation was done. But you're saying it could very well be one and the same, but an external alteration was done.
Certainly.
I see. Right.
I am not a bird shooter or skeet shooter, so I don't know anything about shotguns, but is the choke something that can be modified by the user, by the firearm holder, without necessarily having gunsmith skills?
In many instances, yes.
So we would not want, for example, a sport shooter to be limited, that if he wants to adjust the choke of the shotgun, to have to get some sort of formal permission from the FLA or go to a gunsmith and incur a cost if it's something that can easily be done, and it would be normally done in the course of the different types of targets, for example, that they may be shooting at.
I agree with that, and I would ask the question is, if the spirit of what we are trying to accomplish is, for example, if the weapon is one that was designed where, based on its design, it allows you to do that, to change the choke to a cylinder or other type of choke. If that would be considered, based on the fact that the weapon was designed to be able to function that way, if that would be considered as a modification, considering that it's a part of the design of the weapon, and not necessarily taking the weapon to do a external modification that was not part of the design of the firearm. I'm thinking maybe it would be two separate things based on what you're saying, sir.
All right, in the interest of time, you could proceed.
Certainly.
Present.
So we spoke about the shotgun as well, and it is designed to be fired from the shoulder. It is usually, and I highlight the term usually, a smooth bore because, as I said, the lines are becoming blurred. So you have in more recent times, you have shotguns that have rifling in the barrel, and however, all shotguns are designed to fire shot shells. Most shotguns fire multiple pellets, but you can also fire a single projectile, often referred to as a slug, through a shotgun.
May I ask a question? What's the difference between the type of firearm and the caliber of firearm?
Okay,
and caliber.
So what we are looking at now are different types, and the types, by definition, typically are based on design and how they function, like the pistol, the revolver, etc. The caliber, it just speaks to the type of cartridge that the firearm is designed to chamber. So a caliber would be a 9mm Luger pistol or a .38 special revolver. All of those are cartridge types. Each cartridge types have different dimensions and different design. But the type of firearm speak to the different categories, whether it's a shoulder firearm, a shotgun, a rifle, etc. And just to throw this one in here, this one is actually made in Jamaica. So these are the type of firearms that we see. It's a homemade pistol, where unlike what we normally accustomed to see, those rudimentary one-pop or homemade handguns with a hinge and a spring, a lot of the firearms that we are seeing now are very well made with, relatively very well made with triggers and magazines, etc.
You're saying that this on the screen is one that is made in Jamaica? This
one was made in Jamaica. What I normally do is go through the different types, then I put up the slide and everybody guesses for a few minutes, and then you show you that this was actually made in Jamaica, just to illustrate the point that these are some of what we are seeing.
So it's moved to a lot more sophisticated way.
Certainly.
So that is manufactured here. How frequently you come across guns like those that are manufactured here?
In recent times, not a lot, and I suspect because guns are becoming much more easier to access and come by. So relatively not a lot in recent times. We probably get a gun like of this level make maybe twice or 3 times per year.
Okay.
And this is an example of the type of homemade guns that you're probably typically used to seeing. Something rudimentary with a nail, and you just pull back and it releases under spring tension. So we come to ear gun, or ear guns. What is an ear gun? An ear gun is a firearm that uses compressed air or gas to propel a projectile. So unlike the firearms we were seeing before, and I put in bracket carbon dioxide, not like the explosive firearms that use propellant that causes an explosion. Air guns typically use compressed air to propel a projectile. So the purpose of air guns typically, they are used for plinking, which is informal target shooting, like persons, especially like in the United States and even in the UK, they would set up like little cans in the yard and they shoot at the cans and so. Small game hunting and pest control, so it can kill like small rodents, etc. Well, that's what they use it for a lot. And obviously competitive sport shooting. So the question is, are ear guns lethal? And I note in perusing the act that it didn't make any specific mention of firearms having to be lethal, but this was on the basis of traditionally what I look at, or what we look at as firearms, and one of the thresholds is that it must be considered a lethal barrel weapon. So are ear guns lethal? Well, depending on the specific ear gun, it may produce a lethal injury, and that is dependent on, it says 2, but it's actually 3. The muzzle velocity, the projectile design or type, and the impact location. Quickly, what is the muzzle velocity? It is essentially the speed at which the projectile leaves the muzzle of the firearm. And the muzzle velocity is actually, out of the 2 main factors, they contribute most to the muzzle energy, which is what we're going to look at subsequently. And we have a chronograph there that we typically use at the lab to measure the velocity the projectile travels when it leaves the barrel. Well, also, the projectile design, typically, we're looking at the weight of the projectile. We could get even more technical by looking at maybe like the sectional density of the projectile, which is a ratio of the weight to the diameter of the bullet, but we just look at the weight of the bullet for this conversation, or projectile. And putting all of those together, we get the muzzle energy, right? In the UK, for example, you have to have a firearm certificate for rifles that have a muzzle energy or has kinetic energy greater than 12 foot-pounds for rifles. And any pistol that has an energy greater than 6 foot-pounds is prohibited. Now it is cited in many military journals and literature, and based on standard US military tests, it is concluded that a projectile requires a velocity of 58 foot-pounds to produce a casualty. Well, I can say that many of the ear guns that we have now produce far greater than 58 foot-pounds. So, can ear pistols produce a lethal injury? Yes. Oh, and the third thing that was there, which is not on the subsequent slides, it also depends on the impact site, where the person was shot. So certain areas might be more susceptible than some. Obviously, maybe if you got shot in your eye, as opposed to some area like your skull. To the best of my knowledge, a ear pistol cannot penetrate a skull, penetrate the bone in your skull, but again, it can produce a lethal injury, and that is similar to regular firearms. It is all normally asked which type of firearm has more stopping power. And when you get down into wooden ballistics, you would realize that, for example, across pistol ammunition, the main thing, or most important thing, is shot placement, and not necessarily a bigger cartridge as opposed to a smaller cartridge. Certainly when you move over from the pistol ammunition, going over to the rifle ammunition, then there's a marked difference there. Now, markings, quickly going through.
Excuse me. Having listened to your last commentary about the ear pistol and so forth, in the definition as exists under the existing Firearms Act and what is contained in this new bill, it has if I was just looking at the bill, says that the firearm does not include an ear rifle, ear gun, or ear pistol of a type or caliber prescribed by the minister. What is your, would you leave it as is, or would you, or you are just giving us that explanation, exclude it or do some amendments to that so that there is some other type of control if air pistols are to remain?
So, considering the existing Firearms Act, from what I understand and my experience, as it says, a type that is prescribed by the minister is not a firearm. So essentially, every other type that is not prescribed by the minister is a firearm. Based on my knowledge, I don't know of any type that is prescribed by the minister. I don't know of any schedule, etc. So technically, not necessarily all, technically all air pistols can be a firearm, but it would be depend on, again, based on our examinations, based on, for example, we look at the muzzle velocity or the energy, etc. And based on my conclusion as an expert, I would say this is a firearm. This firearm is capable of discharging a deadly or a lethal missile. So that would be subject to, based on the examinations that are performed. Drawing, to answer it closer to your question, drawing from what exists in the UK, for example, I think that is where the recommendation is there, or the type prescribed by the minister, 12 foot-pounds as opposed to 6 foot-pounds. I would keep that sort of leeway, and I imagine that there would be just a similar, some regulation based on maybe further discussions as to what type of muzzle velocity or energy do we want to restrict as being a firearms, as a ear pistol. Because, for example, the true ear pistol is not what we typically call, or what some persons call ear pistol, like your BB guns that use spring tension. True ear pistols use compressed air. So, based on the fact that there is a threshold that is considered lethal, then I would support personally any leeway that is there as it exists now, where the minister can prescribe that, okay, any ear pistol that has up to this level of muzzle energy is considered a firearm. But I would certainly still recommend that maybe from the administrative aspect that there still has to be some regulation for firearms that even have a lesser velocity than what is considered as a lethal firearm. So that would be my recommendation.
How do you view compressed air fish guns? I mean, when we have because there are a fair number of fish guns, new fish guns which are based on compressed air. The projectile is fired with compressed air, and they have a pretty high muzzle velocity, by my understanding.
They can be lethal, again, especially based on where the person is shot with those fish guns. I believe that there can be some level of regulation for those type of firearms, but especially if, for example, the firearms that are clearly, the ones that are clearly have the likeness and image of typical firearms. So some of these ear guns, they don't look like a firearm, and I mean, it would be akin to just any other tool. Depending on how you use it, then it could be lethal. So my personal opinion is that maybe in terms of over-regulating stuff like that, like a fish gun or something, that may be a stretch in my view, but depending on the type of fish gun, maybe there needs to be some control in terms of the type that persons can actually have in their possession.
To you, Mr. Chairman. I am old enough to remember when I grew up on a farm, my brothers had BB guns and slug guns, which didn't require a license in the 60s. And you know, they use it to shoot bird or whatever. And I don't recall anybody there being an issue around them at that time. When the 70s came and we had a flare-up, then there was sort of a blanket ban of everything, including toy guns. But you cited, if you could just go back to the UK definition. Yes, the one before. No, the UK definition which spoke to the muzzle velocity of what they, right, this one, thank you. The muzzle energy. Would you suggest that something aligned or similar to what is in the UK, where if the rifle or the air gun has muzzle energy less than 12 foot-pounds or 6 foot-pounds, as the case may be, that would not fall under the definition of firearms for the purposes of this bill? Yes,
I would certainly recommend that. And that is essentially what I would try to say, that once there's a level of a threshold that the minister has the ability based on the regulation, just like what we see here, where once it's below a certain threshold, then it wouldn't be considered as a firearm. I suspect that maybe some of the BB guns that you speak of as well are firearms that propel a projectile using spring tension. Certainly most of those, if any, wouldn't have sufficient energy to be able to cause a lethal injury. And I wouldn't want that to be considered as a firearm. Certainly, depending on the context of how it is used, then based on the law, it could still be considered as a firearm. If, for example, it's used in a robbery, etc., then it could be. So markings, when we speak about the make, so we have three, this is a Glock 17 pistol. We have three different types of marks there. The make is usually the brand of the firearm. So this is a Glock. Some companies, the make and the manufacturer is the same. So for example, Glock is a company that manufactures firearm and they name the firearm Glock. Some companies will manufacture, for example, a Glock or another firearm if they have the license, but they are not necessarily the make. So the make is the name of the firearm or the brand of the firearm. It's typically found on the slide. The model as well. So these are the common marks that are found on each firearm and should be on a firearm. The make, the model, this is the Glock 17, and the caliber. The caliber speaks to what type of ammunition the firearm is designed to chamber.
Just a question. Are you saying that type is separate from make and model, and it would be better to put caliber, make, and model together?
So type would be different from all of those, and you typically, well, you wouldn't.
So we have country of manufacture, name of the manufacturer, date of the manufacture, serial number, the type, make, and model, and the caliber. Mm-hmm. That completes it in terms of what the mark?
So, yes, some of those marks, for example, are, you have the typical factory marks, which are the make, model, and the caliber. Some of those marks, for example, I believe it was since 2001 in the US, there was firearm importers had to ensure that the importing agency or importing country or the country of manufacture, etc. Those other marks that I spoke of were on the firearm. So typically when a firearm manufacturer makes a firearm, you will almost always see the make, model, and the serial number. Not necessarily see where it was manufactured, etc. But there are regulations now, for example, in the United States, where the country of manufacture or the manufacturing agency also has to be on the firearm. So these are the typical standard marks that are on the firearm when they are manufactured. Now you have to also have the country of origin, the manufacturing company, etc. And for us here, in observing the international tracing instrument, we are now adding the importing agency. So if it's a JCF, you would see, we would mark JCF on the weapon. The year of import as well, and the, what's the other mark we now want to put? The year of import, importing agency, and there's another mark that we typically put. But essentially, or importantly, we also ensure, well, let me show you, we also ensure that we put these marks on the main components. So this is, for example, a Glock pistol. The Glock generally puts their serial number on 3 areas: the barrel, the slide, and the receiver. What we have done now is that for state firearms that come in, we used to mark the serial number, the importing agency, and the year of import, and all of these locations as well. Because with the advent of like modular weapons, what you will find is that if it is that, or I can give you an example with the FLA, if it is that a licensed firearm is imported in the country and you have a barrel that has no serial number and it is only on the receiver, then any change of any of those parts, any interchange of any of those parts, we are unable to determine on the face of it. We'd probably have to look at the ballistics signature to determine if it is the same firearm, and without being prompted in an investigation, then that examination might not have been done. And I remember an instance where we got a licensed firearm, it had a different serial number on the barrel from the serial number on the receiver. And because internationally the receiver is considered as the control part, it is the main part of the firearm, then based on my inquiries at that time, they weren't recording the serial numbers on all of the locations. I know they are doing that now, but in that instance, then it was difficult for us to tell if this particular barrel is the barrel that should be in this firearm. We probably would have to look further, looking at the initial test fires, etc. So that is why we recommend all of those main identifiers that I spoke to are marked on all the main components: the barrel, the slide, and the receiver. For like your M16 type firearms, which have an upper and a lower receiver, I know of a particular instance, a case that I dealt with personally, where the lower receiver was changed from the upper receiver, and the upper receiver has the main parts that has the signature of the weapon. Because the serial number or those identifying marks are only marked on the lower receiver, then again, it will pose a challenge to identify if this is the particular firearm that was involved in the shooting. So we recommend that all of those marks that I mentioned are marked on all of those main components of the firearm.
Get an indication of where you are in the presentation, halfway through?
3/4.
3/4.
Yes.
Oh, very well. Thank you.
So this is an example of the AR type firearm that I spoke to, where you have the upper and the lower receiver. The serial number and the other identifying marks are typically marked on the lower receiver. So if the upper receiver is changed, then it becomes difficult to identify that this is the same firearm. And those are just some other examples. So firearms with no markings as well, they can be very difficult to trace. And this exists many times based on removal, or they weren't manufactured with those identifying marks. And again, that is as a result of the advent of modular firearms. So this is an example in, I think it was 2018, 19 firearms were found in St. James. When we got those firearms, we realized that they had no make, no model, no serial number, or other identifying marks. And the only thing that was on it was Moriarty. Now, Moriarty is a company, so those marks were there. It's a company that is a licensed firearm dealer in the US that specializes in AR-15 style rifle parts. And so in many states in the US, there's no requirement for serial numbers to be marked on these different components because the receiver is considered as the control part. So if we get a weapon with none of those marks on those areas, then it's difficult for us to trace it back to anywhere. And we see that also with one of the challenges with the 3D printed firearms, which I think I have just one slide speaking to that. So component parts, the current Firearms Act, if not anything, I think this section is one of the most important parts that I want to speak to. The current Firearms Act does not have a definition for component parts of a firearm. And so the legal precedence that is normally used is R versus Elliston-Watson. And what it says is that a part necessary to make the weapon a lethal barrel weapon from which a shot, bullet, or missile can be discharged. Well, in my legally layman mind, looking at it from a technical perspective.
Legal layman is an oxymoron.
I know.
I think you mean village lawyer, from my village lawyer perspective.
Yes, yes. I was just ensuring nobody's sleeping. So we'd ask, these are magazines of the firearm. So are these magazines considered as component parts? Well, the one on the left is a Glock magazine. The one on the right is a Browning high-power magazine, right? Now, the Glock pistol design allows a cartridge to be discharged even if the magazine is not inserted. So is this a component part? Well, based on the precedent that I showed before, it is not, because it's not an essential part for the firearm to operate. Well, look at this now. This is the Browning high-power magazine. The Browning high-power has what is called a magazine safety. So when you remove the magazine, it prevents the weapon from being discharged. So is this a component part? It would, yes. So then, to me, there's a challenge there in terms of the current interpretation of what a component part is, because here it is, if I arrest somebody with a Glock magazine and two persons, one of a Glock magazine, one of a Browning magazine, based on interpretation, one is a component part, one is not. To me, that's a big problem. And to highlight this, my view, what is the purpose of a magazine? Well, a magazine is a container for cartridges which has a spring and a follower to feed those cartridges in the chamber of a firearm. So the sole purpose of a magazine is to feed cartridges into the chamber of a firearm. As a matter of fact, as technical persons, we consider a firearm incomplete without the magazine. So if you submit a firearm to the lab and it has a magazine in it, you don't say that you submit a firearm and one magazine. You submit a firearm. If you give us an additional magazine, then you submit a firearm with an additional magazine. So looking at this, based on my experience dealing with this magazine situation, it is my recommendation, or strongly why a magazine should be explicitly stated as a component part of a firearm.
So tell me your thought now. Here we're moving from the case law definition of component part to a statutory definition for parts and component, which would mean any item that can be attached to a firearm, or any item or replacement items specifically designed for a firearm and essential to its operation, and includes a barrel, frame or receiver, slide, cylinder, magazine, firing pin, mainspring, bolt or breech block. Any part deemed essential for the functional operation of the firearm. Well, that's a repetition. Any part designed solely or exclusively for converting a semi-automatic to an automatic firearm, and any device designed or adapted to diminish the sound caused by firing a firearm.
And I agree with that wholeheartedly. If I can just say that I had several meetings with the team, and I am pleased to see that many of the things that we have suggested, my team, in discussion with the ministry, has been implemented here. So if I may say, I think that this would be guided from our recommendation.
From your technical expert perspective.
Yes. And so even though I realize that it is there, I thought it would be prudent for the benefit of everyone here to understand the perspective as well as to why we made this sort of recommendation as well.
If we go to a part, though, that's less technical than, say, a magazine, the grip, for example, standard grip on a snub-nose 38 revolver is very small. Most men don't find that convenient. You can replace the grip now, at any firearm store. It hangs on the, on the display thing that you can buy it like a slingshot. Would that fall? That would seem to fall under part as broadly defined by the minister a while ago, and I don't think that is. Well, a grip is essential, but not any particular grip is not essential. So they, just like a magazine may or may not be essential, depending on the design of the firearm.
Well, sir, Senator, I would disagree with that. I don't think it falls in this definition based on what I'm seeing, because I don't consider the grip as an essential part.
No, but look at the I'm looking at the definition of parts and components, and it says means any items that can be attached to a firearm. So the grip is surely an item that can be attached to a firearm.
Okay, well, remember I said that I was a legal layman. So based on my interpretation, I was interpreting it to be attached to the phrase of essential as well.
Okay.
So if it is just on its own, once any part that can be attached, I wouldn't agree with that.
Yeah, perhaps we could tighten up that modification. So it's not just any item that can be attached, but something that is any essential item. But I don't want to try and draft it here, but I think that might be a little bit too broad.
So I would consider, for example, and I think it is there somewhere, where like those grips would be considered as accessories. So accessories are items that can be attached to a firearm, but they are not considered as essential to the operation of the firearm. Based on my understanding, I wasn't interpreting the accessories to be covered under parts and components. So based on that example with the grip, I would put it in a category of accessories. I don't know if the intention is for accessories to be considered under parts and components.
So we should add a new term then, or a separate term, accessory, or should we just attempt to modify parts and components to allow for accessory?
Well, what I would
currently the parts and components speak to whatever is essential for the operation. Right.
So I have two slides. I know I promised I'll be finished soon. I have two slides that will just highlight those type of accessories that you spoke of, and then I believe maybe everyone here might be a bit more informed to understand where this should fall. So I put this there, the Glock switch converter, because I know it is there specifically to say any part designed solely or exclusively for converting a semi-automatic to automatic firearm. I know in the United States, this is considered a machine gun. So if you are held with just this converter switch, it is as if you have a machine gun. I agree with that wholeheartedly, and I'm happy that it is there, considered as a component part, with a machine gun component part, whatever it is. I agree with this, because it is a device that can easily be attached to the pistol, and it allows it to be converted from semi-automatic to fully automatic. And as I said before, it is considered as a machine gun in the United States. So this is a quick example. You remove the back plate of the firearm, and that switch is just pushed onto the back of the firearm, and it just has that lever you can move from semi-automatic to fully automatic mode. So again, just to explain the justification why we believe as well that any part like this that can be used should also be considered a component part, even though it is not essential to the operation of the firearm.
Mr. Chairman. Mr. Chairman.
I just wanted to ask a quick question in that regard.
I just wanted to say to you that, just to advise the members, that we are seeing these in Jamaica. These switches are coming in on licensed firearms that are being renewed. So we are seeing them in Jamaica.
Yes, and that is why. Just a quick question here. I just wanted to know that, to clarify whether that Glock converter switch would be considered a form of modification under the proposed new bill. Or is it something that is attached or intrinsic or is included with the purchase of the firearm? Would it be a modification if somebody attaches a converter switch to the weapon?
Okay, well, it depends on the context. So, first of all, these switches are not officially made by Glock. Even if you see the Glock logo on it, etc., Glock, they don't make these. The second thing is that in the context, if you find a person with a firearm, and I remember just recently we got a firearm submitted from FLA through the police office, through the investigator, and it did have a converter switch, and we were able to do our examination and conclude that yes, it's a fully automatic weapon. With the converter switch being attached to the firearm, I would consider it as a modification. But the difference though is that, or the context I was speaking in, is if you don't find them with the firearm, but you find them with this part, then there won't be a modification because it's just the part they have. But this part in itself should be a component part of a firearm, even in lieu of having the firearm. So having it on the firearm, it would be a modification. But having the part separately should be considered as a component part. So that is the point.
You're saying it should also be classified as a component part and also fits into the legislation which prohibits modification. That's what you're saying?
Certainly, and I think it is provided for in the proposed bill that I've seen.
While I'm on my, in law we say on my feet, but while I'm at the microphone, earlier on you drew a distinction between the two magazines. One in relation to the Glock 9mm, which you indicate can fire without the magazine.
Yes, sir.
Just a clarification, is that in the context where you have one in a
one
cartridge in the head?
Yes, sir.
Okay, I just wanted to make clear.
Yes,
so the question that so what comes to mind is this. Essentially, that magazine in that context is not essential to the discharge of the weapon. That's what you're saying?
Certainly.
Okay. So in that context, would that magazine be a component part?
The current interpretation, it would not be a component part.
I see. So we have to look into that then.
Repeat that, sir?
So we have to pay some attention to that.
Definitely, definitely. And that is why I use the two different types of firearms. Yeah. Because if similarly you have one in the head, in the Browning pistol, once you remove the magazine, no matter how much time you squeeze the trigger, unless there's a defect with the firearm, right, then it would fire.
Thank you.
Quickly, accessories are, for example, any item that physically attaches to the weapon and increases the effectiveness or usefulness, but generally speaking is not essential for the basic intended use of the weapon. So the question about the grip, etc., I would consider that as an accessory to the firearm. And here's an example: the laser light on the Glock pistol, or the sights of the firearm, or again, as was mentioned, or the question posed earlier, the grip sleeve. Those will be considered accessories because they are not essential to the operation of the weapon, but they may improve effectiveness of the weapon. And finally, I just browse through 3D printed firearms. So in 3D printing, it essentially uses a computer-aided design model, and it typically, the traditional or common method uses a method of adding material layer by layer to generate a part. So the first known 3D printed firearm was in 2013, was called the Liberator, and it was a 45 ACP pistol. It was made completely by using a 3D printer. These are the parts of the Liberator. Just to note that the only part you have to use a nail for the firing pin. Everything else, all of those parts were completely made by a 3D printer. Here we have some other examples, AR-15 with a lower receiver, so that blue part that is 3D printed. This is called a ghetto blaster. It has a metal barrel, but everything else is 3D printed. So we also have metal 3D printers. The technology is still very young, but in 2013, Solid Concepts designed, they made a firearm of metal using a 3D printer, and they made a replica of the Colt 1911. Now, it's very expensive to produce, but it is extremely accurate and reliable. So this is an example of the first metal 3D printed gun, again, copy of the Colt 1911. So they have several advantages for manufacturers, potential advantages: saves on materials, rapid prototype. You can transfer the designs from one part of the world to another world very quickly, and that is why we also, and I've seen it there, support the idea of having some restrictions towards being in possession of these joints. I know several countries in Europe, they have a similar situation where it is an offense to be in possession of these computer-aided design drawings, and it offers high-level customization. So one of the challenges for amateur 3D printing, it is cost prohibitive. Currently, the technology is still relatively expensive, especially from a commercial point of view in terms of doing it for profit. It is not as easy as you probably would see in some of the movies where you just put in a piece of metal or plastic and click send and a firearm comes out. It takes a lot of skill, but a lot of these, especially these young 11, 12, 13-year-olds, they'll be surprised that they are able to play around with the software. As a matter of fact, just recently I was talking to a colleague and they arrested an adult. He had an 11-year-old in his mother's basement making these firearms with 3D printers, and he gave him something like about $50 per firearm that he made. And he would sell those for 3-4 times the price. So, but it's currently not efficient to produce, but if somebody who has certain criminal intent and not necessarily doing it for profit, this is heaven to them, because they are essentially untraceable. They don't have no any markings, etc. And the technology is improving. In 2018, when I went to I was on an expert panel in Brussels, and the agreement, the concerted belief was that within the next 5 years, the technology will become more pervasive. Well, I can say over the last year or two, I've been seeing the Interpol notices where more and more we are seeing these 3D printed firearms popping up. So it is real, and the prediction was right. So the threats, they have no serial number or other identified marks, thus they refer to them as ghost guns. Another significant problem or potential problem is that they can, they're not easily detected by X-rays and metal detectors. The technology is rapidly improving. A threat, which is mainly to the person who wants to use it, is brittle and poses a significant threat to the firearms in most instances, to the person, to the firer. This is a 3D printed Glock barrel. Well, this is it after the first possible guns. So if we have these prevalent and somebody just are able to just get off one shot, then maybe the weapon disintegrates to the point where you cannot make any identification. Another threat for us as fire examiners, 3D printed metal firearms, if they use the same CAD drawing, they will print the firearms exactly the same, every single firearm. So what you will find, those microscopic details in the firearm would be exactly the same. The ballistic signatures will be exactly the same. So this is a photograph from a colleague of mine. He did an experiment with a 3D printer with 2 barrels. And those are the striated marks that we look at. So the one on the left is A, and the one on the right is B, where you're seeing these striations. So this is the dividing line. So this is A, this is B, and if you notice, they're identical. So if somebody is able to 3D print these firearms, then essentially it would pose a challenge for us to identify which specific weapon fired that ammunition component. And that is the end of my presentation. Thank you.
Thank you very much, Soup Bernard, for your thorough presentation. Any further questions from full?
I join you, Chairman, in thanking ACP Bernard. Very informative and useful presentation. It means that I know the work was done in consultation with yourself and persons from the Institute, but we may have to just seek your comments on a few matters. So currently we have firearm that is defined to mean any barreled weapon which discharges or is designed to discharge any shot, bullet, or other missile. We're to amend the part which says 3D printed firearm, because I suspect it includes those created through technology, like the 3D printed technology. And then the prohibited weapon unless the context otherwise requires, and it includes the parts and component. Does not include air rifle, air gun, air pistol, or a type or caliber prescribed by the minister. I think we will have to revisit the entire definition, Chairman. All right, we have about 40 minutes before we take the break at 12:30 to enable the chambers to be refreshed in time for Parliament. So if there are no other questions, and we would just go through the provisions. And perhaps if he wishes to stay, he could stay.
Yeah,
Chairman.
no problem.
Right.
We can.
So we will now pick up at clause 27, Madam CPC.
Good morning. 27, declaration of firearms that may be imported or exported. The Minister may, after consultation with the authority and the Commissioner of Police, by order published in the Gazette, declare the type and caliber of firearms that may be imported or exported.
So just a quick observation having regard to the presentation of ACP Bernard. It's whether the institute, consultation with the institute should be involved here. I know the officers also form part of the JCF, but I think that is the part where the expertise would lie in respect of advice on type and caliber of firearm. Chairman, we just note it for consideration.
Yeah. 28, National Firearm Control System and Firearm Control List. 1, the Minister shall prescribe the National Firearm Control System, which shall consist of A, the procedures for 1, administering the import, export, transit, transshipment, and brokering of firearms, ammunition, and other conventional arms, and 2, processing applications for authorizations for the importation, exportation, transit, transshipment, and brokering of firearms, ammunition, and other conventional arms, and B, the firearm control list, comprising the matters specified in subsection 2. 2, the firearm control list shall include A, all items and technology prohibited or restricted by any provision of this Act, and B, all parts and components and other items and technology, the import, export, transit, transshipment, or brokering of which the Minister considers it necessary to control for any of the following purposes. 1, to restrict the importation of firearms, ammunition, and any other category of conventional arms, any prohibited weapons, or any items or technology deemed capable of being converted thereinto or made useful in the production thereof, or otherwise having a strategic nature or value. 2, to ensure that firearms, ammunition, any other categories of conventional arms, any prohibited weapons, and any items or technology deemed capable of being converted thereinto or made useful in the production thereof will not be made available to any destination where their use might be detrimental to the security of Jamaica. 29, marking of firearms. 1, a firearm imported into, exported from, transited or transshipped through, or manufactured in Jamaica shall bear a mark identifying, in respect of that firearm, A, the country of manufacture, B, the name of the manufacturer, C, the date of manufacture, D, the serial number, E, the type, make, and model, and F, the caliber. 2, notwithstanding subsection.
Just listening to that, these identifying marks on the firearm, in light of what was said earlier on about the serial numbers and so forth being on the various components of the firearm, would that be relevant to the set of information that would be required on that at item 29.1? Specifying or requiring them to fall.
So serial number should be on
the 3 different components, rather than just serial number.
Well, yeah, based on the presentation, that makes some value. I mean, what's your...
Through you, Chairman, member, since a firearm is defined to include the component part, then it would stand to reason that the matters enumerated in the clause would be required to be marked on the component part as appropriate.
Yeah, that is my thinking,
right.
But it's not explicitly stated here. It just says, for example, in respect of the serial number to be on the firearm.
There's one concern here. At that area, bear in mind, the manufacturers, they're not manufactured in Jamaica. So different companies have different levels of serial marking. Now, we, in this legislation, we will be accommodating with the laser marker we have. They will be marking different components of the weapon. So wherever that is in law, that could be stated. Well, if you put this in there, then we'd have to ban some of the firearms coming in. I would have to prohibit weapons coming in because the manufacturers will be deciding where they put their marks. And we run into another problem.
Okay.
Yeah. So they have a serial number. The FLA will be doing markings that can.
Let's
we have
see
that
the-
regulation come, we'll have to
subsidy
indicate they have to mark all
subclause.
parts. But if we put it here, then a significant number of the brands will not be able to come in.
Two, notwithstanding subsection 1, a firearm imported into Jamaica under this act may maintain an alternative unique mark permitting ready identification of A, the country where the firearm was manufactured, and B, the serial number, make, and model of the firearm. 3,
Just to be clear, for B, that alternative would be sufficient. ACP Bernard, you could. So, because this is a smaller subset, which is hosting the detail
This is
that's
now referring to the
provided.
local markings, Minister. 2
Yes.
will now come, and 3 is what we'll do locally.
Right, so it's an alternative that would comprise only the country
No.
where the firearm was manufactured and the serial number, make, and model. All right, we can proceed.
3, the Institute shall mark all firearms owned by the Government of Jamaica in accordance with the guidelines set out in the Government of Jamaica firearm marking standards, and the registrar shall cause the information related to the firearm to be recorded in the register. 4, the authority shall be responsible for marking all privately owned firearms delivered up for marking in accordance with this act, and shall, A, mark them in accordance with the guidelines set out in the Government of Jamaica firearm marking standards, and B, cause the information relating to each such firearm to be transmitted to the registrar for recording in the register. 5, the information referred to in subsections 3 and 4 shall include the following: A, the country of manufacture; B, the country of import; C, the importer and end user as set out in the Government of Jamaica firearm marking standards; and D, the year the firearm was imported. 6, the registrar shall cause the information transmitted to the registrar under subsection 4 to be recorded in the register. 7, the authority may seize any firearm that has not been marked in accordance with this section.
Mr. Chairman, I just want a clarification. I'm trying to understand why is 29(1) A, B, C, D, F necessary if we then have 2AB, which says notwithstanding subsection 1. Why add that complication? Why not just make just have one clause with A and B? Why, for example, do we need the date of manufacture? If you have the country of manufacture,
Antique.
the name of the manufacturer and the serial number, you know, if you have the country where the firearm was manufactured, the serial number, make, and model of the firearm, which is 2A and B, why would you need more than that?
There is a system for a authorization for collections, antique collections, and that's set at a particular
For antique
date.
collections.
Yes, and it's set at a particular, those manufactured.
So
on or
in order
before,
to know whether it qualifies as antique, that's why you need the year.
among other things, yes.
But the manufacturer, once you have the serial number, make, and model, the manufacturer can always verify in those very, very small instances of antique guns what year it was manufactured. Do we need that printed on the gun? Because typically it would not have been on the gun when it was manufactured, particularly if it's an antique.
Hi,
The question is whether you need
good
two
afternoon,
after 29.
Minister and Senator. So it's really making a distinction between the marks that are required at the points of manufacture and the marks that are required at the points of import. So the year of import would be relevant for tracing purposes. If it is that the country did not manufacture the weapon, then we would want the year of import to be a part of the mark for the purpose of tracing.
Yes, but clause 2, which speaks to a firearm imported into Jamaica, does not mention anything about the year of manufacture. So it goes exactly opposite to what you're saying.
Okay, sorry. So just to further clarify, 29.1 would be the marks that are required at the point of manufacture. However, based on what the international instruments have indicated, countries can import firearms that bears the marks that are set out at 29.2. So that would be like an alternate mark that you could look at the point of importation.
Right, and since we're not manufacturing any legal, we don't have any legal manufacture of guns in Jamaica, wouldn't 2A2 be sufficient?
Okay, so no, Senator. So if it is that the weapon was manufactured in the US, we would want everything that is set out at 29.1 to be on the weapon at the point of importation. That's what we are saying here.
Maybe the expert, the ESP, could help us, because I have never seen any weapon that carries ABC 29.1 A, B, C, D, E, F marked on the weapon. Is this a new standard?
For that, Ms. Allen, you said 29.1 was intended to capture the date of import, but that is not what is provided for at
And one is to capture date.
Sorry, no, Minister, not the date of import, because that would be one of the categories that are set out here now at 29.1. The date of import would be what we are trying to capture at number 5. So that mark now would be the mark that DPM has indicated we would place on the weapon when we import the weapon. So we would want to record when we imported that weapon into Jamaica.
ASB, for comment, my understanding, 1 refers to markings which the manufacturer puts on, which we have not to do. It is when you're buying the gun, it has that.
Yes.
2 also has, but if all that is on it is what is 2A and B, we can still import the gun. Right? So I don't think we have 1 and 2 refers to the country where we're importing from. Then we get to 3, 4, and 5, which is what we do with the gun, internal markings.
But typically, a handgun would have the make, model, and serial number.
Yeah, you're asking if
so
in
I'm
one...
asking
one
the
ASP,
with all this information, I've never seen a weapon with all this detail on the weapon itself.
That's number 1 you're referring to know. All these things may not be on the gun.
Right.
ASP?
Yes, Chairman. There are a significant number of firearms that do have everything that is set out there, 29.1A to F, but certainly there are still many weapons that wouldn't have all of those details on them. So they are, and it sometimes it depends on the make of the firearm. Some companies will put the country when it was manufactured, the name of the manufacturer, etc. Some firearms will not have all of those information. So the typical that you are certain to see is the make, model, serial number, and caliber.
That's the lowest common denominator, Mr. Chairman, and if that is, we know that's going to be common across all. Why don't we make that the basic requirement? I mean, if you have the make, model, serial number, and caliber, I mean, that's a pretty unique set of identifiers.
Weapons coming from like the US, you will have those other details.
No, I'm saying if you have more, fine.
Yes.
But don't set the bar that high that, for example, you may not be able to import a Walther which only carries the make, model, and serial number.
Yeah. The would ask the question, they should have these on as well as 2A and B, but so it would not, this is not preventing us from importing.
Exactly, Minister, and that is the objective behind how we would have set it out. So 29.1 is really to establish the higher standard. If it is that the firearm doesn't meet that higher standard, we have 29.2 that says notwithstanding 29.1, once you have the serial number make, we would allow the importation of the firearm. The higher standard would have been in accordance with the international obligations.
Oh, it is. They now require that all those things on every internationally. That's the new standard.
That is the new
but
standard.
Not every manufacturer would be meeting that standard now.
Exactly, Senator.
Okay. All right. Thank you. I'm advised.
Removal, alteration, etc. of a mark. 1. Notwithstanding Section 16, the addition or modification of a mark on a firearm may be effected in accordance with subsection 2, and the addition or modification made in accordance with subsection 2 shall not constitute an offense under Section 16. 2. The addition or modification of a mark on a firearm, A, shall be done only to correct evident errors in the marking on the firearm, and B, may only 1, be made by an authorized officer or a gunsmith at the direction of the authority, and the authority shall forthwith notify the registrar of the addition or modification as the case may be. 2, may be made by an authorized officer at the direction of the director of the institute, or 3, in the case of a firearm recovered by the police in the course of an investigation, be made by a constable acting in the course of his duties with the authorization of the Commissioner of Police, and the Commissioner shall forthwith notify the registrar of the addition or modification as the case may be.
Chairman, on the last point that was made, if I understand it correctly, I'm wondering about the practicality of it, in the sense where it says recovered by the police in the course of an investigation. I know it is a common practice where if the police recover a firearm, they would put maybe an X somewhere or an initial or something for identification purposes in court. And we saw it came out in a trial in the courts right now, where a rifle was left, it didn't have a serial number, and they were unable to conclusively identify because they didn't put that mark on it. So it is a common practice in the course of a criminal investigation by the police. And I'm just wondering how practical it is, where we go further to say that the authorization of the commissioner and the commissioner shall forthwith notify the registrar of the addition or modification. I'm wondering about that final sentence, if it is practical.
The clause is seeking to ensure that where firearms are recovered in the course of an investigation, those firearms are marked and recorded so that you don't hear that the same one recovered from X crime scene turns out to be the same one then recovered at YC crime scene, or they come into the system and go back out for whatever mysterious reason. So the mark that is required to be done and the notification is to enable a recording of it for identifying purpose, for tracing. So if it has to be reworded, then rewording can take place, but that is what it is seeking to do, to take care of the problem that we hear of firearms being recovered in certain scenes and then they go back out, and the same ones that are recovered are the same ones in circulation.
So they require marking by the FLA, the police, or laser marking. Wait, for it to be genuine, you have to mark with some kind of...
Not the FLA, Chairman. The
No, I'm just
FLA
saying the police is to mark. I know that's what they're saying. When I'm saying they get it marked that it is not removable. You have to get a laser marker. It has to be marked with a laser machine.
Sorry.
If you just
No, just listen to both commentaries a while ago, and hearing from Minister. It seems that the officer, superintendent?
Assistant Superintendent.
Assistant Superintendent.
Thank you for the promotion.
And it said in the true. But it seems that the discussion is on two different issues. Your marking is for the purpose of the court, but I'm understanding from Minister Malawi Ford that this marking that is being made is for the purpose of registration elsewhere and to ensure that firearms that are recovered don't go back out, or there's some record that is made. So it may end up being two different types of marks. Yes, so it doesn't seem as if there's an issue.
yeah, no, I understand that. I'm just saying that if you're going to get it, it will have a marking that will be irremovable. Therefore, you know, if you just mark for the court with a pen, anybody can change that. Even nail can be corrected very easily. No, the only thing I can remove is the laser marker, so I've said it to be the same.
Well, Mr. Chairman, the overarching objective must be to control that firearm, what happens to it, whether for purposes of the court or the case, or for it to be to leak back into the system. There have been a lot of allegations, I'm not saying it's substantiated, but a lot of allegations that weapons that were recovered years ago find their way back into the system because there's not a comprehensive control system for those weapons that are recovered. And I think this would assist in that regard. But before the ASP answers, all of this, Mr. Chairman, is around the firearm. I recall as far back as when I was minister, seeing presentations that they know manufacturers have the capability to mark the cartridges. And in some countries, now for example, the ammunition and the cartridges in particular for whether the police or the military have unique...
No, photolithographic equipment, which we are seeking to acquire for the FLA, to mark all bullets when they come in the country.
To mark all the cartridges?
All the cartridges.
And?
In addition to the rifles, all cartridges will in future be marked.
Okay.
So that we have as well.
But is it provided for in the Act?
I'll be advised now.
Because there's always a lot of stories about leakages, for example, from ranges, etc.
Right.
You have the potential, if a range imports, 9mm rounds, to mark, to link each cartridge to the range. To link each cartridge that's imported for the GSCF.
We're comfortable with that. I
GDF.
think, no, the agreement is there in policy. I just want to be sure that it's in the regulation of the law because we are getting the photolithographic machine, right? So the FLA will mark all cartridges before they go to the retail sale, right? But I think in this case, the marking referred to, I was going to ask the SP funding. And I can see what they're saying. Marking it for the court may not be as demanding as that because once you have it and it's still the weapon, you will get the ballistic markings very soon. Then if it's recycled, you'll know that the gun is recycled. I think it's just to protect it between the acquisition of the firearm at a crime scene until you get it to the ballistic center, right?
Yes, sir.
Okay, but you could do it with your nail at that point.
So if I may comment on the 2 points. One, in terms of, and my intervention was seeking to identify the practicality in terms of during the course of our investigation. And this is what is practiced on a daily basis. This is what I see in the courts where the officer has to identify the particular item. Not only the officer, but the experts. So in most or many instances, when I am called to court, I am asked, is this the firearm that you examine? How do you know that this is the firearm that you examine? Well, this is the mark that I placed on the firearm. So if we look at, I believe it was a 2 be made by an authorized officer at the direction of the director of the institute, that would fall under what we do on a daily basis. So when I get a firearm, there are specific places that we place our mark on it. In the context of the conversation about the recycled firearms, or firearms potentially being recycled, that is what is often, well, I won't say often because it doesn't happen often, but that is what is used to identify, not the mark that the police officer would put on it for the purposes of identification in court, but the mark that is placed on it when it comes to the institute. We examine it, we place our mark on it. So if in those instances, and during my tenure, my 14 years, I've probably seen about 3 of those instances, or 4 at most, where we were able to identify, we did the necessary, wrote the requisite reports, and the investigation was launched. We were able to identify the number or the identifying mark that was placed on it when it came to the lab. The mark that the constable would place on it would be necessarily for that type of identification. It would be based for identification in court to say, this is the item that I submitted to the lab.
So let me ask you, so there is a chain of custody that you have to secure with integrity. So Officer X says, I went on Y scene and I recovered this firearm.
Certainly.
He's required to mark it. And for practical purpose, the power to mark there is given to the constable who is acting in the course of the investigation.
Certainly.
And then there is a reporting up to the commissioner. All right? And then that is turned over to the ballistic expert
Certainly.
for testing to get to the certificate. What is the difficulty that you're seeing? It would be not necessarily the same mark, but your police is saying, this is the one I had recovered from this particular crime scene, marked as follows, and also is the one that was turned over. And then you in turn would say, this is the one I received. You can make reference to the mark that was on it when you receive it, or you put your own mark as a way of identifying it. There's a difficulty in that?
Well, my
practical purpose?
Yeah, my comment at the time was looking at where we say that it shall be forthwith notify the register of the addition or modification. I was thinking about it in terms of practically how it operates on a daily basis. For every time investigator A puts an X on the firearm, then there's a requirement for him to make that.
Well, the course of investigation is, it didn't say at the point of recovery. So the course of investigation gives a little latitude. One would certainly expect a timeliness in the turnover of matters. But also bear in mind that under this regime, the penalties are massive. And there is a concern that is expressed about planting of firearms, recycling of firearms, questioning the integrity of investigating officers. And so this is part of the safeguard mechanism in the law. It may be a little onerous, but it is the Crown that bears the burden of proof, and will have to ensure that the chain of custody and the evidence in relation to the chain of custody to ground the offense of possession will be made out. So there is kind of very little getting around the state discharging its duty in a particular way, and it really over time shouldn't be viewed as onerous, because nothing less than integrous handling of these matters would be required. So you're closing the gaps that would cause reasonable doubt in a proper investigation and prosecution.
Minister, the chain of custody would require identification at the very point of recovery, which would be the serial number normally and the various parts. If they don't have a serial number, then you have to mark it.
So the data, recall Chairman, had shown that you'd have to provide for a situation where the guns may be manufactured locally
Yeah,
and don't
no,
have
I'm
their
saying,
own
but
marking.
they are the vast minority said 4 million, but it would have to be marked then by an acceptable marking until you get to it.
Yes.
Yeah. It's understood.
Chairman, through you.
Go ahead. Member
ASP,
Superintendent.
yes.
Mr. Colonel.
When the firearm is received by the lab, you assign what they call a FL number
Yes, sir.
to the case. That FL number is what you use to mark the firearm, to identify that that is the particular firearm that you received.
Yes, sir. Yes,
Okay.
sir.
Just want to be clear on that.
Yes, sir. That is the common identifying mark that we place on the firearm.
And
when it is
that
received.
FL number, if the firearm is used in another FL case where you got cartridges that you assign the FL number, you can interconnect those.
Certainly. So we can look at the records. So, as I say, in maybe the 3 instances where we were able to identify that FL number in that location, we'd put it in a conspicuous and inconspicuous location. So when we identify that and we check our records and say, okay, this is a Taurus pistol, this case was a Taurus pistol, then we'll go further to look at the signature, etc., and confirm that it is the same firearm.
And for the purposes of the chain of custody, when the officer submits the firearm to you that he has already marked, you would normally give him a receipt with that FL number on it.
Certainly.
All right, thank you.
But the definitive mark is still ballistics. So when you assign a number, when you recover a firearm, you eventually get the ballistic marking. If another firearm comes with the ballistic mark, that makes a difference. If it comes with the same ballistic marking, then it's the same gun.
Yes, sir.
But the critical issue is recovery to the institute is the chain of custody, critical element, the chain of custody, because if a person changes the gun in between, then that's where you have the problem.
Yes, sir.
Right? So understand. So
there are internal and external information. The internal information will be the ballistic signature. The external information will be what external marks are on the firearm. The point that was made by the minister, I understand the point. I was just making my intervention based on how practical it is, where when the mark is placed, the investigating officer would write a statement stating that I went to such and such a place, recovered this firearm, I placed X mark on the weapon at this location, etc. And that would be in the statement. And then when they go to court, it would be based on that they would identify that this is the firearm. When we get the firearm, we would also place a mark. And so we would be also able to close that chain in terms of this is our mark, that is their mark. And if it is recycled, then we'll be able to identify those marks as well as confirm the ballistic signature. But I totally understand the point. As I said, my concern was just about how practical it is based on how firearms are recovered on a daily basis and the officer placing an X as to, but I understand the point.
So, I'm grateful for the feedback, of course, because you don't want to make it unworkable, and that is why it's the course of the investigation, because certainly you would have to complete the case file to include receipt of the ballistic certificate for submission. So it's at some point during that investigation and not necessarily on the point of recovering it.
Understood.
But if there is any suggestion, of course, to ensure that the way it is framed, it doesn't make it unworkable, now that you know what we're seeking to do, then that feedback would be welcome.
Madam Chair, I think, Mr. Bernard, Madam Chair, I don't know if we've got Mr. Bernard. I think Mr. Bernard is saying, as it relates to the practicality of it, with the authorization of the Commissioner of Police.
Ask me a bit thicker.
I think Mr. Bernard is saying the practicality of it during the course of an investigation by a constable with the authorization of the Commissioner of Police. He's saying in the course of the investigation, the constable needs to mark that firearm, and he can't mark it without getting the authorization of the Commissioner of Police. And he's saying that's the practicality issue he's having in terms of every single marking there that the constable has to make. In the course of it, he has to get the authorization of the Commissioner of Police. And how practical can that be?
I see. That's why I said if a little rewording so we don't have the unintended consequence. Of course, the information that there has to be some oversight and accountability up, right? So it's deliberate that there is some reference, because if remember the firearm now, we know it's wreaking havoc, but under the new framework it's treated in a particular way. So all officers who are investigating and who recover are expected to deal with the investigations with a certain level of circumspection and accountability within the JCF itself, going all the way up to the top. Some serious penalties are on the book. But we will look at it and see. We know what we're seeking to achieve, to just see what wording is required. So if I'm recalling, it was really the transmission of the information to the registrar for the addition of the modification by notice. But we'll mark it, we'll mark the subclause to revisit the wording.
Can I just ask a quick question? Where a firearm currently is recovered without a suspect, are those firearms submitted to your unit?
Every firearm recovered in Jamaica is submitted to the forensic lab. Should be. Well, as far as I know. If I may make one more point, because we're talking about ammunition and a comment that was made about marking cartridges, just for us to consider. It is recommended that ammunition, it is recommended that ammunition possessing identifying marks is done, that mark is done at the point of manufacture for efficiency and practicality. So for example, I know the JDF, I don't know if they still do it, but I know the JDF, for example, when they go directly to the company that they purchase the ammunition from, they say, okay, we want 10,000 5.56 rounds, but we want JDF mark on the head stamp. And we see them. And that is practical because of economies of scale. They can build it in the process.
This could only be done by the manufacturer. It would not be practical for FLA or any other agencies to try and mark it. This would have to be at the point of ordering it. Those manufacturers who can, who have the capability or who are willing to do it, all of them I imagine have the capability, but who are willing to do it, and you would do it by, certainly, you may not do it for the individual firearm license holder who buys 50 rounds per year or whatever it is, but for those who are high users, high volume users, the JDF, the JCF, and certainly the ranges, then I think it could be practical to require that.
So that is essentially the point that I wanted to make, where if you think about it, Mr. Dallin maybe could be best tell in terms of the private use, how much cartridges are imported on a yearly, weekly basis. But I'm certainly, when you look at it on a yearly basis, it's hundreds of thousands of rounds. So in terms of marking all of those cartridges before they can be released to private citizens, you will have some challenges there. Another problem is that many of the private dealers, they don't purchase ammunition directly from the factory. They purchase through a broker. So they don't necessarily have that ability to negotiate to say, I want these marks on it prior to being submitted. So that is just something that, as I said, based on my experience and looking at the practicality.
So as a practical matter, it would be the JDF and the JCF who would be the agencies that it would be practical to have their ammunition marked by the manufacturer.
No, well, certainly, on the face of it, yes. Certainly if the state, or, because it depends on where the burden will be. I know the private persons, they will push back, and maybe it will probably affect the cost of the ammunition as well, to push back to actually do it. So if the state can manage to mark this ammunition, I would certainly recommend that because it would assist us greatly in the course of our investigations. But putting it on the table in terms of the practicality of marking upon import those thousands of rounds, I'm not certain if the state has the capacity.
Right, and I wouldn't necessarily suggest that. I don't know how practical that is. But I was really seeking your expert opinion on it to see how practical. I know their capability is there, but whether it is a practical requirement is really what I was seeking your advice on. And I think you're saying now, with the possible exception of the security forces, it would not likely be practical.
It would be difficult from my perspective. I'm sure maybe Mr. Dallin might have a perspective on it as well from the private firearm importers' perspective. But in terms of from the state, it is possible. And but for the private owners, I see it will be a challenge.
Well, yeah. So and ASP, Bernard, the fact that the cartridge is not marked does not preclude you or the lab from making a positive identification, whether it be in respect to the cartridge or the projectile.
It does not, but it provides a distinct advantage. Because when we are looking at which firearm fired the cartridge, which potential scenes it is connected to, then those marks wouldn't prevent us from making that determination. But when we're looking at larger, looking at the source of the ammunition, who are the persons who are funneling this ammunition into the criminal underworld, then certainly those marks would assist us to identify any leakages or maybe source of that ammunition.
Yeah, I get you. So what you're really saying is that it's just the practicality of it. We have to work that out. So you basically have to throw caution to the wind in terms of how we proceed with a wholesale application of that approach.
Certainly.
Just to say, Senator Sinclair, maybe you should raise the point you raised quietly with me in respect of 32.3.
Yes, how the clause is drafted in 30.2.3 restricts it to the police as against, say, JDF, say against smoker. It restricts it to the marking. In the case of a firearm recovered by the police, if suppose
so we need to provide a little more widely that where the firearm is recovered, not necessarily by the police, but say by a soldier or anyone who's conducting an investigation.
The same thing on page 29.
What needs to be done, because the principle would apply regardless of who recovers it. So we'll just flag this again. Madam CPC, let's try to just...
Sorry, just to point out, member, because...
let's just complete 31, Chairman. 30, we have subclause 3.
We can't go beyond 31. The host needs to prepare now on 30.
2 minutes it will be done.
It's going to take discussion.
3 here is to complete the clause itself, 30.
Sorry, I just wanted to provide some clarity for Member Sinclair in respect of firearms recovered by the JDF. They're actually sent to the police. And the MOCA officers are authorized officers based on the definition, so they would fall under subclause B2, authorized officer.
Less than 29, section.
3. Let's go to 3.
No, well, we'll have to close sharp, not later than 12. Whether we have to halfway through, or we can't hold the parliament. No, we can't go that far. Don't think it's a discussion. Continue CPC 32. No, we can't get here.
3, where the registrar receives a notification under subsection 2B1 or 2, or directs an addition or modification under subsection 2B3, the registrar shall make such corrections to the information recorded in the register pursuant to section 29 as may be necessary.
Okay. All right. Yeah.
31, capture of ballistic signature and other information in relation to firearms. 1, the Institute shall be the responsible entity for capturing ballistic signatures and other information in relation to firearms that are the property of the government of Jamaica. 2, the authority shall be the responsible entity for capturing ballistic signatures and other information in relation to privately owned firearms. 3, the information to be captured under subsections 1 and 2 shall be prescribed by the Minister.
If we can pause here for the day. It's now 12:35. I promised the sun down 12:30, so it took 5 minutes of your time. So, let me thank the members. Today may have done to cover a few sections, but I think it's a very good day in terms of technical information and the support from the Institute, and better prepares the members for understanding why and how we do the regulations. So let me thank everybody. Just one thing, we did
Mr.
make
Chairman, what's the first presentation? Was it circulated? Could we have it? Could we have
Can
it
be circulated from
yes,
please.
Could you circulate your or send your slides to the committee clerk so we can look at it?
It's a very useful presentation. I think was there to be another presentation by the FLA? No, no, good. So this was, but I think it was this was another useful one in face to face. So we may have to look, but we will consider doing some hybrid to keep all the members engaged. 1 and 2. Look at the rate we are going. I was hoping we'll be finished by the end of March. No, I captured all the spaces up to the end of March. But
Mr. Chairman, the schedule is very demanding.
Right.
For those of us who are not full-time employees of the government, you are asking a lot. And I mentioned it to you informally this morning, but I want to ask now, can we make these meetings hybrid so that those of us who are not full-time employees of the government, it will make it a little more convenient for us to incorporate it in our schedules, make it a little easier?
No, accept it, I said, because this was the thought from the beginning. When the resolution was moved, we did agree that we could have a hybrid meeting, but we thought at the beginning, because a number of issues were on the front loaded on the schedule, on the section 1 and 2, we thought it would be good to have face-to-face meeting. I think after this presentation, we can begin to. I don't know if we can do it tomorrow by hybrid, but certainly by Thursday, we can organize hybrid and continue thereon. All right? So we do it tomorrow and then proceed from there on hybrid. All right? Now we need to keep everybody engaged. It's going to be both. Not so channels interesting and an education process, which was maybe due for some time dealing with all of this critical nature. Yeah, tomorrow is face-to-face, but I think Thursday we go hybrid, so it gives time to reorganize itself for Thursday and therefrom. All right? So we adjourn until tomorrow at 10 a.m. We thank the members again for coming out, and the technical team, who has, especially those who have been in it for the long haul from day one in the preparation of the bill. But it's an important bill, we get it through the House and get it active. And my technical director said to get the date of appointment, Mr. Richards, designated. Thank you all very much. Till tomorrow, 10 o'clock. And the House later on. Adjourned.